going live now.
There we go.
Hey, everyone. Welcome to another episode of On the Record with your host, Tone Vase. And today I am joined by Bill Restis, who's a lawyer in the space and recently filed a class action lawsuit against Coinbase. So go ahead and say hi, Bill, and then give us a little background about yourself before we get into the case and other things that are going on in the crypto space in regards to law and regulation.
Hey, good morning, Tone. Bill Restis here from San Diego. I am a class action attorney, have been for over a decade, and been practicing in the securities space with securities class actions. And about middle of 2017, when I was in the middle of a sabbatical, really started to dig into the crypto space pretty hard, and has become a fascination of mine and a key part of my practice now. I'm have been one of the attorneys involved in the Tezos case, and my second class action in this space has been against the Coinbase, as you saw. I've been helping some companies now since I've been getting my name out there a little bit, raising money on the blockchain. People seem to think that when you sue ICOs, that you might know how to keep them out of trouble. So that's what I've been doing lately. Tone, I lost you for a second. I don't have sound.
Oh, sorry, I muted myself. That was my bad. So on the Tezos case, did you work with David Silver at all?
We've talked with David Silver a little bit, and I'll keep those conversations private. There was different lawsuits that were filed. His was filed in Florida. His case has been dismissed, and our case, which was the first securities case that was filed, is in the Northern District of California. What's going on in that case right now is the judge is comparing all of the applications for who will control it, what plaintiffs will control it, and what attorneys will control it.
I gotcha, because I just had David Silver on my show the other day, probably about a week ago. So is this a new development that his case was dropped?
No, so it's pretty standard practice, is that there becomes a lead case in a securities class action. You have to have something where there's all these technical requirements, and I don't want to bore you with the details, but they get all grouped together in front of one judge. There were about 5 cases that were filed against Tezos, and the judge is picking the lead case and the lead plaintiffs and attorneys, so that there aren't a multitude of litigation, that there's one litigation.
Gotcha. I see.
He's in the mix. The court hasn't decided yet, who's in charge.
Okay, I gotcha. Okay, this started to make sense. Man, I had no idea that by joining the crypto space, I would become like an authority on securities, law, taxes. Like everyone is like going to me as a YouTuber for these answers. I'm like, guys, my advice is about as good as you're paying for it.
Well, it's where the action is, I guess, right now in the space, right? Is everybody's trying to figure out what laws apply, what box do we put this into, and I think that's important. The base layers for the crypto revolution have been developed. You've got the base layer coins, and now we're trying to figure out what we're doing with them.
So in your law practice, what is your expertise within the law space? Like, what do you normally do as an attorney?
Well, there's been a shift again over the past year, broadening my practice a little bit, but it's been traditionally class actions, which has its own very unique rules that go along with it. Like we were talking about the Tezos case and, the procedural issues with that. And a lot of it has been with securities. Before I went on sabbatical and started my own firm, I was dealing with some, what do they call it, high frequency trading issues and cases that dealt with the plumbing of the financial system, and the duties of broker dealers with executing trades and best execution and things of that nature.
Gotcha. All right, so let's just get right into it. I'm gonna start with I'm gonna go to screen share for a second here. let me, I think this works. I'm gonna share my desktop. I'm
Yep, I
curious
got
how it looks on people's end. Um, I think the boxes are gonna be in the corner here. Um, so Wait, I was gonna, this is
wrong
my
screen.
Twitter. I was actually gonna go to your Twitter, but that's okay. But this is your law firm, Restis Law. So you are, do you have partners here? Because like your last name is Restis. So are you the sole practitioner?
At this point, yeah, you know, when you start a new company, you can either bring people on initially and then share the value with them, or you can develop the value yourself and then bring people on at a discount. And that's my strategy at this point.
Gotcha.
Get
And
the brand going, and then bring on some very key people that I have in mind.
so here's the specific lawsuit that we are going to be discussing today a little bit. And you filed this on the 2nd of March. This was Friday. And this has to do with Coinbase violating California's unclaimed property, specific code 1500. And maybe you can give us a little bit of a background, how like you came across this and why you felt that this is a good lawsuit, because you do have two specific people mentioned in the documents.
Yeah, so I mean, I'm going to be kind of circumspect about the case because it is pending litigation, and you know, everything I say can and will be used against me in a court of law. So, but basically, what the class action is about is people who sent Bitcoin, Ethereum, Litecoin, perhaps Bitcoin Cash through Coinbase to users outside of Coinbase by email. And what we found out is that for much of the history of being able to send Bitcoin via email, that a lot of people, when they received it, they never claimed it. And so there's a real issue of who owns that and what and where should that unclaimed Bitcoin go. The current situation has been that, you know, we found at least a half a dozen people who were sent it and never claimed it. And, you know, where there's smoke, there's fire. And it shouldn't be kept by Coinbase. It should be distributed to the people to whom it was sent. And if it's not distributed to the people whom it was sent, it should be turned over to the state of California. You know, there's unclaimed property laws in every state that apply to financial institutions. Let's say someone dies and they have an account that's been unaccessed for a while. Banks aren't allowed to keep that. They have to turn it over to the state of California. For example, in California attempts to try to locate the people and reconnect them with their lost property. And if it can, it goes to the state. So that's really what this lawsuit is dealing with is, you know, the best analogy, and we used it in the complaint, is, you know, imagine if you had written a cashier's check to someone.
Do you know what page that's on by any chance?
I think it's the first paragraph right there.
Okay.
Paragraph 1. You know, if you have a cashier's check that the money is taken out of your account, it's not cashed. The money is not the property of the banks. It is the property of the recipient. And so, you know, that's the issue, is what happens when no one claims it.
Gotcha. And so after I tweeted this out, because I found this very interesting, several people have said that they got their Bitcoin returned to them. So what does that mean? Does that mean, is this like a selective process? Do you think that means that people in the older days, before Coinbase really knew what they were doing, those Bitcoins are kind of in limbo, but they kind of realized, let's say, I believe your incidents go as far back as 2014 or so?
I think it was the specific plaintiffs in the complaint received the emails in 2013.
13, right. So
Right.
Is it possible that Coinbase has figured out that this became a problem around 2013, 2014, and as of, let's say, 2015, 2016, they dealt with this in a different way, where perhaps if the Bitcoin wasn't claimed by the recipient, the sender gets it back after 3 months, 6 months. Have you heard people come out and mention that?
Yeah, I saw your Twitter feed. There were people who said that it was returned to them. So there may have been a change in practices. If you look at Coinbase's terms of service, they actually mentioned this California law that says unclaimed property has to be turned over to the state of California. So, whether or not it's, how big the problem is just a question for discovery in the case. But I have had other people reach out to me and say that the same thing that was alleged in the complaint has happened to them. So at this point, we're just sort of like looking through a keyhole into a dark room, and we don't know what's in the dark room until we turn the lights on. And that's what we're trying to do.
Right. Now, I've always been curious how these class action lawsuits go. You mentioned two specific people, and I believe one of them never claimed 0.1 Bitcoin. The other one didn't claim 0.01 Bitcoin. So in reality, the actual, value and dollar amounts in the specific case written down is pretty small. But if let's say another 30, 40 people from that period of in time come out and say this happened to them, can they be added as plaintiffs to the class action lawsuit?
Well, the class action lawsuit is designed to cover people who aren't parties officially to the case, right? So the whole concept behind a class action is that you have one person or a small subset of people that adjudicates the rights on behalf of everybody who had similar situation. And so to answer your question, no, we don't need to add people to the case. Assuming that these two individuals, that their claims are typical of everyone else, and I suspect that they are, anyone who falls within the same type of injury as the named plaintiffs will get wrapped up into a class. And if the court looks at the case and it progresses to a certain stage that it thinks the case has validity and that the class should be certified, notice would go out to people, and they would be able to decide, whether they want to be included in the lawsuit or not. Usually it's an opt-out process. So for a class action, you're in it until you're told that you are out.
I see. But you have to find out who those people are, or those people have to come to you.
Well, usually that happens through discovery, right? We would go to Coinbase and we would say, give us a list of all the people that, who were sent unclaimed Bitcoin. So for example, it might be a list of email addresses. Then that would go to a third-party administrator, people who handle class action notice on a regular basis. And, most likely those email addresses would be sent some sort of a notice informing them of the class action and that the class action was attempting to reclaim Bitcoin for them. And it would allow them to make a decision whether they wanted the class action to decide their rights over these Bitcoin, or whether they wanted to, for example, let's say someone received 0.1 Bitcoin, right? They may want to not deal with all of the litigation. They'd want the class action attorneys to handle it for them. There may be someone who was sent, let's just use hypothetical, 1,000 Bitcoin, and they'd say, my dollar value of this is pretty high. It's I may think that I can get a better deal than on an individual basis than a class, being a member of a class, and they may opt out of the litigation and pursue an individual action against the defendant on their own. So class actions are designed to give people the lazy option that they can stay in it and let people like me do our best to get them compensation, or they can decide that they want to take it upon themselves to assert their own rights.
I see. Yeah, because I'm learning a lot here. This is why I find interesting. And I think with this unregulated crypto space, the amount of class action lawsuits against many of these companies are going to go up and up and up. And I think most of the early Bitcoin people are going to be intimately familiar with the class action lawsuit process, which is why I don't mind bringing people these podcasts. So
Mhm.
now Coinbase seems to be, somewhat responsible company as far as paperwork goes. What happens in a class action lawsuit like this, where you put in an inquiry to a company to get their records, and their records are very shoddy, or they maliciously lie and don't tell you everything?
Well, and I'm going to speak generally instead of about Coinbase.
Right. This is why I also phrase my question generally.
Right. Well, I tend to like it when the defendants try to hide evidence, because that's a very, it's, let's just say it's extra naughty and courts hate it. So, in this case, I suspect that this is just a record keeping issue. I mean, what's difficult about this case for me is that, we took a look with the state of California to see if Coinbase had any property that it had contributed, under these laws, and there was none, and we couldn't find any identifying information for the people who had received these bitcoins, and that raises some concerns about their record keeping, at least early on. So, for example, if someone sent Bitcoin, was it segregated in Coinbase's accounts? If it wasn't segregated in Coinbase's accounts, what does that say about Coinbase's business model? So if you have a Coinbase account, are there actually Bitcoin that are segregated for you or not? And I think that's a real issue here. And because if Coinbase, let's say in 2013, someone had sent someone 0.1 Bitcoin and it was never claimed, and that 0.1 Bitcoin has just been sitting around waiting to be claimed, that's a lot easier for Coinbase to deal with, because versus the situation where if it was just a cash flow management issue, and the Bitcoin was not actually there, and now Coinbase has to come back and purchase essentially a Bitcoin to cover these liabilities, at 10 times what it was originally sent for. That's concerning.
Oh, yeah, that's interesting. Though I highly doubt it would be the latter, because a person would be sending that Bitcoin to someone else. So they did withdraw that Bitcoin from that person's account in order to send it. But you're right, that is going to be a question. And lots of lawyers can accuse companies of running Ponzi schemes the moment they see unsegregated accounts.
Well, I don't know if it's a Ponzi scheme, but it may be a fractional reserve system, just like your traditional banks. And I think that is one of the reasons why people are in the crypto space, is because of the whole, difficulties with fractional reserve banking, and, what that means for the issue of sound money. And hopefully, those types of business practices aren't replicated in the crypto space, because it takes away all of the benefits of owning it.
Gotcha. All right. So was this something that you guys tried to resolve with Coinbase before going to this kind of an option as a class action? Was Coinbase, did they have ample chance to make good on at least the people that you worked with, or is this something you really wanted to do an open case?
Let's say that Coinbase was just non-responsive, and there's some strategic considerations that go into that, and there's a problem. I guess it's a good problem in class actions, where if a defendant comes back and makes the named plaintiffs whole, those people don't have a ability to make sure that everyone else is made whole as well. You have to have something called standing in order to be in court. So, one of the things that we didn't want to do is for Coinbase to come back and give, for example, these people their zero point 0.1 Bitcoin or their 0.01 Bitcoin and have potentially far larger amounts go uncompensated. So in order to make sure that these rights are represented, we need to have the class action mechanism to go forward.
Gotcha. Okay, that actually does make sense and is pretty interesting. So
because sometimes, in the class action space, you could send somebody a letter and say, hey, there's going to be a class action. This person lost X, Y, and Z. The defendant says, oh shoot, litigation is coming. Let's get rid of this plaintiff so that we can just deal with this one guy or one girl and not have to deal with everybody who has the same problem.
So Coinbase was notified, but not with the names of the specific plaintiffs in order to avoid that situation.
They were notified. It's just a big company, and they are
right.
Right.
Okay, interesting. Starting to learn more about how these things work. Okay, so another thing that I'm finding interesting is in both your case, because there was another case filed, and maybe we'll briefly talk about that other case a little bit later. But the one thing, because again, I'm new to this whole law space and suing people. Now that I'm a public person, so maybe I might end up on a defensive side of one of these things one day. So at the very top, in nice big bold letters, and I've seen this on many, many class actions, it says trial by jury demanded. Now, what is the significance of that? And why do I see this in both of the class actions against Coinbase?
Okay, so this is just a standard claim that a plaintiff needs to make at the start of a lawsuit if they want a jury trial or reserve the right to a jury trial. So some types of claims, and without getting too far down into the weeds, some types of claims can be tried by a jury, and other claims you can be tried by a judge. And so if you want to reserve the right for that, you have to put it front and center in the initiating document. So whether or not a jury trial would actually occur in this case, or whether these particular claims, there's definitely a basis for there being a jury trial, but you have to reserve it if you want the ability to take it later.
Okay. Okay, makes sense. All right.
Yep.
Thank you for that information. Okay, so what happens next? What are the next steps? Because these things usually take years and years and years. And I know I've gotten some crazy class action lawsuits like in the mail where, I don't know, somehow, like because of my credit card purchases or something, I get like a letter saying, we are suing, Vico, the coconut water maker, because they lied about so-and-so on their label. And I'm like, wow, I really like that coconut water. Like, why would I want to be part of this like class action lawsuit? I'm going to make like less than a penny at the end of the day. So these things do get out of hand, but like, what are the next steps? Like, what happens next? Are you guys going through that discovery, trying to find the names of every single person that sent out Bitcoin over to like a long time ago? It was 2 years. And now you're going to send them letters? Like, what happens next?
Yeah, so, as you said earlier, that the wheels of justice move slowly, and especially in cases like this, they can take a significant amount of time. So the first thing that we're going to have to do is Coinbase is going to have an opportunity to review the lawsuit, decide how it wants to respond. It can usually in class actions, there's something called a motion to dismiss, which is because the stakes are so high, the defendant usually tries to get rid of it at the earliest stage possible, telling the court that there's no there, and even if everything is true in the complaint, there's still no right to relief. Once that gets resolved, and I seriously doubt that this case will be dismissed, then you go into something called class certification discovery, and the court would allow us to see whether there is a class. And what that usually looks like is, did the named plaintiffs have an injury that is similar to everyone else that they're seeking to to sue on behalf of. So, we would take an inquiry into the named plaintiffs, what happened to them. We would take a look at Coinbase's policies and procedures. We'd see, for example, whether, this failure to return Bitcoin was an isolated incident, whether it was discrete, what time periods it occurred, how broadly it occurred, who it occurred with. And then all of that evidence would be presented to the court, and the court would say, yeah, it looks like there's a group of people here. They all had the same thing happen to them. So we can adjudicate all of their rights in a single lawsuit. That usually takes somewhere around 6 months to a year to decide that. And then if the court says, yes, it looks like there is a class, then they'll send out the notice. And that's where you get something in the mail. Most of it happens these days in email, and everything's done online. And so that would probably what would happen if the class is certified in this case is that people who had received these original notifications from Coinbase that they had received Bitcoin would be sent another email, and they'd be told, hey, you're part of this class. Unless you tell us you don't want to be a part of the class, sit back and wait. If the case is successful and we recover Bitcoin for you, you'll receive further notice on how to claim it. Now, when you talk about just a little bit, and additionally about like your coconut water, I think you're right that there's some extreme examples of class actions that are, and I don't want to use the word frivolous. I mean, obviously, if somebody violates some kind of advertising law or says there's natural or whatever in a beverage and it's not, should the company be allowed to get away with it? I don't know. I don't tend to like cases like that, because they give class actions a bad name. But when you get into situations like this, where there's, potentially real money here, it could be tens of millions, it could theoretically be hundreds of millions of dollars. And, what we can't do is we can't let companies have a business model where they get their revenue, through, I guess you could use the term unfair business practices. Class actions are really the only cop on the street, and I think they're very beneficial to, to businesses. But I probably am a little bit biased.
Right. So, so it's good that you made that distinction, because class action lawsuits do have, have gotten a pretty bad rep over the years. And they're kind of like, oh, it's just a lawyer trying to make a bunch of money. And you agree, a lot of the class action lawsuits are getting out of hand. And the ones you like are the ones with very specific victims with potentially bigger victims somewhere in the background.
Yeah, I think that's right. I mean, we hear about these extreme cases, where, like you said, someone gets a penny. But I've been involved in lawsuits where people have received thousands of dollars. There was a particular case I was involved in, 6 or 7 years ago. It was an insurance company was targeting senior citizens and charging them upfront load. So anyway, long story short, people were getting back $50,000, $100,000. So, there's real value there if the case is right. And I've received a lot of very thankful responses from class members over the years for getting them some real recoveries.
Okay, I see. All right, so let's. Anything else you want to comment on this specific case, and then we can move on.
I mean, I'd like to talk less about it. As I said,
right.
It's my own case. I probably have more to say about others.
All right, so let's take a look at another case that actually came out the day before yours. I thought they came out on the same day. That would have been great. I don't know if you looked over the details of this case, but this case talks about how I believe that it looks like they're accusing Coinbase employees and insiders from profiting on the sales of Bitcoin Cash because of they had some insider information. I think specifically the price of Bcash, I can't believe I called it Bitcoin Cash for brand confusion purposes. The price of Bcash rose to like $8,000 on Coinbase. And I personally know people. I was having dinner with them at the time, and they ran, like they didn't run, but they grabbed their cell phones. They tried to frantically log in. They called their relatives to frantically log in to sell Bcash at the height of 8,000, and no one was able to even come close. So does this have to do with that part of it, that they were showing a price that no one could actually sell at, or the fact that they had insider information and some people were able to sell if they were insiders? Maybe you can clue us in. I skimmed this over. I didn't have time to read into the details.
Yeah, what's interesting to me about this is the whole notion of insider trading. And what it says to me is, okay, how can we have insider trading? So you can have insider trading and market manipulation of securities. You can have insider trading and market manipulation of commodities. But at this point, we don't have really market manipulation laws with respect to, for example, Bitcoin or Bitcoin Cash. So what's interesting to me about this is that if we're going to say that you can be liable for manipulating a market, we have to classify cryptocurrencies as a type of an asset class that is subject to these anti-manipulation rules. And so I think that's the significance of this case. The problem with it is, at this point, unless we say that a Bitcoin is a security or a commodity, then these rules don't apply, and there's really no basis to say that there should be liability for insider trading.
Right. Now, it's actually really, really interesting because, again, I worked on Wall Street, and my understanding is you could, get busted as an institution for market manipulation of, say, a commodity, where Deutsche Bank, I know, got busted for manipulating the price of gold by like 5 cents or something, because they were one of the banks that would declare the price of gold twice a day, and they would purposely quote it 5 cents lower in order to profit from that little bit of price. But I believe that is different than the insider trading laws and regulations that we have, because as far as I understand it, a person cannot be accused of insider trading a commodity or a currency. As far as I know, that is something that applies to like the stock market only, where you have some kind of insider information that you're not supposed to know. But in the currency space, it's a little bit tricky because you don't really there is no like insider information on the euro itself. But now we're getting into this whole governments thing. Like, governments have some insider information. Somebody knows when the peg is going to fail. So the question is, who knows? And if you can get accused, this is a big problem in the current financial space too, in that you can't accuse someone of currency manipulation because it's a government thing, and insider trading laws don't really apply. But in the Bitcoin case, it's also going to be really, really interesting, I think, which way it's going to go, because Bitcoin is its own asset class as far as I'm concerned. And we're going to get to the CFTC thing in a second. So you're right. I don't want to see Bitcoin get classified and be subject to insider trading laws on Bitcoin, because a couple of idiots decided to fork Bitcoin for Bcash. And this lawsuit could have ramifications on Bitcoin itself, not just the derivatives of Bitcoin.
Right. I think generally, I agree with everything that you've said. And you're right. There's no specific insider trading rules with respect to commodities. There are market manipulation rules. So, for example, putting false and misleading information into a marketplace, whether insider trading is a species of market manipulation, I haven't gone all the way down into the weeds on that specifically. But, I don't think that it's a good thing, for example, that we can have people coming out on Twitter or issuing press releases, I guess you could say, that are good or bad, or news articles that have false information that affect the marketplace. Now, that's probably not a good idea. People can disagree with me on that, but I think that if we can tie this case in with something that happened in the Southern District of New York last week, where a judge ruled that Bitcoin could be classified as a commodity and regulated as a commodity under the Commodity Exchange Act. And so what that does is that opens up all of these market manipulation rules to cryptocurrency trading. And whether or not that's a good thing, that's a normative analysis that everyone has to make. And I think there's probably arguments on both sides, but the answer is it's coming. That type of analysis is going to be coming to this space.
Yeah, it's going to be interesting. If I had to choose a regulator, I would probably choose the CFTC over the SEC because of the commodity side of things. An at-home trader is pretty much will never be accused of insider trading on that, as opposed to having it classified as a security. And being such a global asset like Bitcoin, is going to be interesting how other jurisdictions see it. But I also found that CFTC case to be kind of interesting because, as far as I understand it, the CFTC will still only have jurisdiction over the commodity when it's being traded with leverage and margin, but in the futures market, it's kind of one and the same. So, for example, CFTC has lots of oversight and regulation over gold futures, but CFTC has absolutely no jurisdiction of me buying a gold coin from you or from a gold dealer down the street. They don't really have any kind of oversight over the physical exchange of the commodity peer-to-peer.
I can't, it's my understanding, and again, I haven't worked that much in the commodities space, but it's my understanding that the CFTC does have jurisdiction over spot markets. So take that as you will.
Yeah, I'll ask that to my gold dealer. I'll ask him if he's ever considered the CFTC as part of his business as a potential regulator. I'm actually really curious myself.
Yeah, and I think when you were talking about, for example, Deutsche Bank, the settlements with the manipulation of the gold fix, you're right, that was under the Commodities and Exchange Act, but the other cases that were brought against them were under the antitrust laws. And there was also some Forex cases where there was manipulation in the Forex market, and those were antitrust cases. So there's really different regulations that apply depending on what type of activity. I don't think that any of these crypto assets fall exclusively in one box or another. It's sort of like that old saying where there's six blind people trying to figure out what an elephant is. One is feeling its trunk, and the other's its tail, and the other its leg. I mean, so that's really what the regulators are doing here, and everybody seems to think it falls within their sphere of influence. And I think until there is comprehensive regulation in the area, that's what we're going to be dealing with.
Interesting. And okay, so let me get your general views on how you feel about the current ICO space.
I've written a couple blogs on this. I think that we're going to see a significant cool down in ICOs in 2018 and going forward, and we're going to see something that is newly emerging now in the security token offering. Practitioners and I think a lot of participants in the space, first of all, the issuers themselves are scared that they're going to be doing some kind of activity that violates some regulation somewhere. So, and then attorneys, who are advising these projects, just I think it was last week or the week before that, even attorneys advising the projects are getting SEC inquiries as to how they're structuring their deals. And so where everyone is going is to try to assume that at least securities laws apply and to try to treat offerings as securities. Now, that doesn't necessarily mean that the tokens themselves are securities, but the securities laws really deal with fundraising. And when you're dealing with fundraising, that's when you get into issues of disclosure. So that's a long, that's a really long-winded answer to a short question. But where do I see it going? I see the space moving into an assumption that these types of assets should be treated, at least prophylactically, as if they were securities, even if they're not, to avoid intrusion by regulators.
Gotcha. And how bad do you think, I mean, what's the worst and the best outcome, would you say? Bitcoin aside, I'll ask that question next, right? So like what's the best versus the worst outcome for all of these companies trying to go ICO and the lawyers and the advisors involved?
Well, the worst case scenario is that you have criminal enforcement actions for things that are clearly scams, and you have people going to prison. Certain things like BitConnect come to mind, where anyone who had any, and this is no offense to anyone in your audience who was invested in BitConnect, but for example,
no one in my audience was ever invested in BitConnect. You're not going to offend anyone, trust me.
Okay. There's some things that are very clearly, obviously scams, and that was one of them. And I think the regulators are going to be concerned with a couple of things. One is, first of all, is there going to be real value that is being offered in exchange for these tokens, right? Is there a real economic rationale for them, instead of just having a project tacking blockchain to it and issuing a token?
If they brought me on as a consultant, my answer would be none of them have any economic value whatsoever.
Well, yeah, I mean, so I think there's certainly some instances where I think there is, and I can talk about that later. So the regulators are going to be concerned with, is this a scammy project? Number one, because the laws, the regulation, regardless of whether people like it or not, is, and whether they agree with this statement, is at its base intended to protect investors in the orderly operation of markets. So the second one they're going to be concerned with is disclosure. So, are potential investors being provided with all of the risks of a project? Are they being told where the money's going, how it's being used, who's involved? And so again, that seems to be, even internationally, a chief focus of the securities laws, is making sure, they're not trying to have a nanny state, but they're trying to make sure that when you buy something, that you have at least the ability, should you want to inquire, is to find out what you're investing in. And then the other one is going to be restrictions in certain instances on who can buy and who can resell these tokens. And usually that's a restriction to accredited investors, and that's people with certain assets and income, or institutional investors. And so when you mix all those together, you can come up with compliant tokens and compliant offerings, but you have to treat them as if they're securities. So, and what's the best case scenario? I think the best case scenario is the market starts to realize that these types of regulations aren't a death knell. I think that every time we get regulators making comments, markets go down. There's a lot of FUD out there as a result of that. But, as a person who's in this space, I tend to view it as a positive because, we don't want to go back to a time when it was buyer beware and you had to, because most people are not that sophisticated. And as we've seen, for example, with BitConnect. So that's what these regulations are intended to do.
Gotcha. Yeah, because I have been very critical of Ethereum. And to me, I personally don't see any difference in the way in what Ethereum did versus what Tezos did. The only difference is Ethereum were able to launch the token while Tezos didn't. I really don't see how a future like SEC or court that decides how these tokens are collecting money for their projects. How is something like Ethereum was any different than Tezos, other than in the end, the investors in Ethereum were able to become rich by selling the token, and the investors of Tezos never got it. But as far as collecting the money, I don't understand how they were ever any different.
I think the focus really is on fundraising again. Everybody.
No, I agree. I completely agree.
So how is it different? I don't know. I don't know how big of a distinction there is. I can tell you that there's a statute of limitations, and at least for private actions. So, for example, a securities class action, the time has expired for anyone to bring anything related to the Ethereum ICO.
Oh, that's interesting.
At least for me, I don't, and not to say that I'm interested in that, but the SEC may have and usually does have longer time periods for that. But I think that you're going to see more of a focus on projects that because there's limited enforcement resources, right? So if an ICO happened and value was provided, people made money, I don't see too much of a concern from a regulator unless they're specifically trying to make an example. But because there's other projects that don't really fit those criteria, they would be probably more immediate targets of securities regulators.
Interesting. Okay, I haven't considered that one, that Ethereum might be around too long for the regulators to accuse them of launching an unlicensed, unregistered security, because I did sit down over a year ago now with a security lawyer, and we talked about how Ethereum was an unlicensed, unregistered security launch, but I haven't factored in the fact that the SEC might look at it and say, we missed that one and it's too late.
Right. So, for example, just if I were to bring a securities class action, I have to do it on behalf of people that had damages. And this
I had damage. I knew that Ethereum was an unlicensed, unregistered security because I understand how securities work, and
right.
That's why I didn't invest in Ethereum, and that's why I'm not a billionaire. Because I accused them of doing so at the pre-sale, and I could have bought a lot of Ethereum at 20 cents, but there was a reason why I didn't.
Yeah, I mean, that's not the type of damages that really the law agrees is compensable. So, but that doesn't mean that a regulator can't, the regulator doesn't have the same restriction on damages. So they could bring an action against a group or an individual simply because there was a technical violation of the law. Whether they intend to use their resources that way is anybody's guess.
Okay, so in that case, here's a hypothetical, right? Because I know Ethereum's going to fail because technologically it can't possibly scale. And if Ethereum does go, technologically down the toilet, and that token, all of a sudden goes back to below its original pre-sale price of 20 cents, what can happen then?
Like I said, okay, so now we're getting kind of into the weeds of
Yeah, this is like if my dream of Ethereum, completely imploding from a technological perspective occurs, and I want this to occur sooner than later, because the later this happens, the bigger the global fallout from the unwarranted confidence in the Ethereum technology. So I want this to happen sooner than later. But if that actually happens, and yes, I am cheering for this. Like I said, I want it to happen sooner than later. If Ethereum goes belly up technologically, like I know what happens if Bitcoin goes belly up technologically. You're not going to be able to find Satoshi and and go after him. That's not going to happen, right? So if Bitcoin goes belly up, people hopefully I'll be able to predict it price wise, and then I won't be, I won't have all this hate on me because I'm a big Bitcoin supporter. But in general, if Bitcoin goes belly up, it's kind of like the internet going belly up. There is really nothing you can do about it. But if Ethereum goes belly up from technological purposes, there are specific people that could potentially face damages, correct?
Yeah, so the securities laws, at least, and again, we're talking obviously in the United States. They divide investors into two classes. There's the people that were the original investors in the ICO, and then there are the aftermarket participants. So the investors in the ICO, it's only those people whose investments are compared to the original ICO price. And in the aftermarket, it works. It's far more nuanced in calculating who would have a claim. So let's say, and again, we're trying to take old legal concepts and apply them to, new technologies. So there's not always a perfect fit, right? But typically how it works in a securities class action, let's use a stock, okay? Let's say the stock the price of it was artificially inflated because there was some sort of, the books were cooked. The market thought that, there was $1 of earnings per share when really there was only 50 cents. That was concealed. The stock drops, and then the investor lawsuits come. So generally, when you can have losses, for Ethereum, would depend on when a person bought and if they actually lost money, and if the loss was actually related to some sort of undisclosed, for example, failure of the Ethereum ecosystem. So let's say, for example, Vitalik has a knowledge, 100% certainty that, and I'm just spitballing here, with your hypothetical, but let's say Vitalik knows for sure that Ethereum can't scale and the whole project is doomed, and that information is not disclosed to the marketplace. People are buying Ethereum at high prices. He finally comes out and says, you know what, guys, we can't do it. The technology doesn't work. The price of Ethereum crashes. Well, maybe that might be a securities fraud case, but only in the instance if we can classify Ethereum as a security. These are very interesting. Frankly, something I've never thought of before, but it's an interesting hypothetical.
Yeah, that would be interesting. Personally, I mean, people significantly smarter than Vitalik have tried explaining this to Vitalik, but he's being delusional over the ability of Ethereum to scale. So we'll see. We'll see where it goes, and hopefully, he can be caught on camera or in one of his interviews saying something dumb that will hold him liable and accountable for it.
And I mean, I think this is a good question in terms of is this the type of market that we want? Do we want founders of these projects to be required to disclose information that they know about it? And everybody thinks that regulation is a death to the crypto space, but at the same time, it isn't that something that we need in order to get institutional investors to invest in this market? Isn't it something that we need for, I guess, mom and pop to say that, this isn't the magical internet money where there's no rules that apply? I personally think that once we define whatever these rules are for the crypto space, it's going to be a boom.
Now, you said something really interesting in that statement that you probably didn't realize the kind of consequences it would have. You specifically started that paragraph with founders of the project. And this is the key word, I think. Something like Ethereum, something like Zcash, something like Dash, maybe even Bcash, right? Because there was a hard fork initiative that created a different coin. So that one is maybe. But almost every one of these projects that even claims to be decentralized, I mean, none of these ICOs claim to be decentralized, right? But Ethereum still thinks they're decentralized. So does Zcash think they're decentralized, so does Dash. These things do have founders. And that's the difference that something like Bitcoin doesn't. And when you said, do the founders have a potential future legal obligation to disclose these kinds of flaws? And this would become very interesting because, for example, about 3 or 4 years ago, there was a major vulnerability in the internet itself. And it was kept so hush-hush, and only 3 or 4 programmers knew it, and they tried to fix it. Now, the internet is a little bit different than something like Bitcoin because there's actual money and investment on the line that could cause a panic. And thank God Bitcoin doesn't have a founder and doesn't have a leader, because if 1 or 2 key programmers of the Bitcoin protocol find a serious vulnerability, they need to keep it to themselves as much as possible in order to fix that vulnerability, in order to not cause a potential panic in the market, completely annihilating all market value. And if that vulnerability can't be fixed and that vulnerability is eventually discovered, how liable can those developers be even when they're not founders?
Probably not much. We're really getting on the far reaches of what anyone has really even contemplated at this point. So I think we're a couple steps ahead. It's sort of like trying to put the windows on the house before you put the foundations on the house, right? So first of all, what we need to do is figure out what boxes these various, crypto assets fall into. I think there's definitely distinctions between projects where there is, a mining of the currency and projects that have, an initial allocation to founders. Because the closer that we get, everybody's focused on securities law. And I think that that's probably the most apropos to this space because, what we're dealing with is when you rely on a third party to manage your investment, that's what the securities laws are concerned with. They're concerned with the fact that I'm giving my money to a company and there's the officers and they may be doing X, Y, and Z to manage my money or my investment properly or improperly. And the more we get to a situation where there's individuals that are in control of a project, the closer we are to say that the securities laws will probably apply. And the more decentralized something is, the less likely it is that we could say the securities laws would apply. Because there's a reason, we start from a basis of why do we have these rules, and then we go from there.
Okay, so let's, I don't know if you want to comment on this. So let's jump from security laws to potentially money laws and FinCEN recent statements that for some reason they seem to claim jurisdictions over utility tokens. Now, I found that to be a little strange that they seem to be classifying utility tokens as in potential violation of money transmission laws without actually declaring that these utility tokens are money. Now, I know they're money. FinCEN knows they're money. They're obviously money because even Ethereum is a utility token that is being used as money. But they're not. But there is nothing that I saw in the FinCEN statement that classified these utility tokens as money. So to me, it seems like a giant gap in FinCEN's view of it. I agree with them, but I don't like the way of the overreach of the law on paper without dotting the I's and crossing the T's here.
Well, I was able to skim that FinCEN notice. It came out, I think, last week. And it was my understanding that they said, look, if you're exchanging one cryptocurrency for a new cryptocurrency in an ICO, that potentially could be a money transfer business that would be subject to Department of Treasury regulations. And then FinCEN, of course, is concerned with money laundering and criminal activity. How I read it was, they're reserving the right to pursue ICOs under the money laundering laws, to the extent they think they're being used that way. I didn't see it as a blanket, grant or claim of regulatory authority there, other than to say we're here. If again, it's like the elephant example I came up with. So
Right.
concerned with money laundering, and they're saying, well, if you use the ICO platform as a money laundering tool, then we have jurisdiction to go after it. That's
Now,
how
now, now, here's the thing, right? Like I've been listening to a lot of Senate hearings, and again, like I'm learning so much about like the laws. This is completely crazy. That's something that I expected on doing. But here's where I'm starting to get confused. I've recently, like from what I've been reading, money laundering laws is something that strictly applies to money earned from illegal activity. So if you are acquiring cryptocurrency by, let's say, selling a legal product, like not selling drugs and, or whatever, right? Let's say you're acquiring Bitcoin or any crypto for that matter by providing legal services or selling t-shirts or whatever, you may potentially be in violation of tax evasion if you don't claim it as income properly. But I'm not sure how they can get you on money laundering, because as far as I understand, money laundering has to involve illicit means of income. Or am I wrong on that? Or maybe you're not an expert in that
No,
field.
I'm not an expert on it. I'm not an expert on it, but what I can say is that the various different regulators are going to look at this and say, if an aspect of a crypto project falls within our field of regulation, then we're going to regulate it. We're not going to say that, we don't have jurisdiction over this particular issue simply because it's a new technological vehicle for doing it. And I think that that's what's happening, is the regulators are out there and they're saying, okay, we don't have a specific set of regulations that apply to cryptocurrency yet. So we're not going to let it fall into the void, and we're not going to say that this is the Wild West and there's no rules. We're going to say that traditional rules apply to these concepts, and we're going to apply them until we have a better solution.
So how do you think this ends? I mean, do you think this will go all the way to the Supreme Court one day to decide, what is a Bitcoin, what is a decentralized digital asset, and will 10 years, 20 years from now, it'll be its own asset class with its own regulatory body that is not any current regulatory body? And would that regulatory body end up being global? Because we can't control what the bureaucrats are going to do. How far do you think this is going to go? And I'm thinking it's going to go as high up as possible, where there might need to be like a global Supreme Court one day to decide on these global decentralized assets. And then, of course, the people that are using those assets don't have to listen to those decisions, but they would need to be aware of them.
Well, I think that that's just an issue with the law generally. Anytime you have something that crosses borders, you have issues where, what jurisdictions laws will apply. And I think what we're going to see is the development of best practices. That's already starting to happen in the crypto space. And the law tends to, at least in the United States, we have a system that's based on decisional law, where you have a patchwork of court decisions, and those court decisions, they're based on a specific set of facts. And they don't usually go beyond those specific set of facts. So what happens is you get an increasing quantity of factual situations that have been decided on their own terms, and then you can group them together and you can start to paint a picture of what is and what is not, for example, a security or a commodity, based on, you know, the facts and circumstances of any particular case. Right now, you know, there's just not a lot of detail to work with. And, you know, for example, the Tezos case, unless the SEC comes out with some, you know, far-reaching regulation that applies to this, you know, the Tezos case is probably going to be the first one that you know, actually goes into the weeds on this. I mean, it's always possible, you know, that the founders of the Tezos project could say, you know what, we don't want a court to decide whether or not this is a security, because suddenly that's going to have implications for everybody else. So maybe they'll say, let's get out of this case and not, you know, leave that question unanswered. In terms of having, you know, a global regulatory space, you know, good luck. I mean, you know, it happens with tax laws, for example. One jurisdiction pops up with some tax laws, and then companies, you know, they move offshore, they go to other places. And I think that's what regulators are really trying to balance right now, is, especially in the United States, if you saw the CFTC and the SEC chairman testimony before Congress a couple of weeks ago, they said, look, this is a really important technological development. We don't want to kill the golden goose, you know, but we can't have lawlessness. So you're going to have this tension between regulation and not driving projects to other jurisdictions.
Yeah, and I think it's going to get even more interesting with a lot of these, maybe not so much regulators, but maybe a lot of these politicians holding these ICOs, holding these cryptos, and maybe their kids are holding on to them. And, you know, this desire to get rich may have a lot of influence in how the law gets shaped.
I absolutely think that that's right. I mean, you have some very wealthy, powerful people, particularly in Silicon Valley, that are heavily invested in this. Tim Draper, for example, is one. And, you know, when you have money behind these projects, you also have regulatory influence. You know, just to go back.
Well, not just that. I'm going to a bigger conspiracy of, let's say, the judge himself is holding a bunch of this ICO token because you can hold it anonymously.
You could, yeah, you could. I mean, that's generally something that is not allowed. So I would never assume that a judge would, you know, violate the rules.
Well, not even a judge, even like a jury or the regulators or the politicians that are going to write the bill. And because a lot of these things could still be held anonymous, you just don't know what the potential implications could be going forward.
Right. Well, you know, it's the more people hold it and the more lawmakers hold these things, I think the better it is, because they're going to realize that they don't want to throw the baby out with the bathwater. And I hope that that's what happens.
All right. I think we're good. I think we can close out here. Maybe just do a quick recap of where people can find you, how you came onto my radar with your court case against Coinbase, the class action. And we have one specific question from an audience member, from the live viewer. And I know what the answer is, but maybe you can throw a couple of comments in. So his question is, does the Coinbase class action lawsuit mean that the state of California could potentially be required to hold Bitcoin?
Yeah, I think that's really interesting, because I think the answer is yes. Now, required to hold Bitcoin, how would they be required to hold Bitcoin? I mean, maybe they only have to take a zip drive or a nano and put it into a safe deposit box, or maybe they would have to set up Bitcoin addresses, and it could spur the state of California being a, you know, investor or holder of cryptocurrencies, which has, you know, a whole slew of potential implications, right? Obviously, if there's states that are using and holding Bitcoin, that's bullish in my perspective. So just a little bit about me. Again, you know, one of my main focuses now is in the crypto space. It's restislaw.com. I've got Twitter at Restis Law Firm. And I'm helping investors and, as I said, also founders of crypto projects who want to build a compliant, I guess you can call them ICOs, even though we're trying to I think you're going to see that phrase fade out, I think. Yeah, I look forward to talking with any of your audience members that have interesting issues that they need to have addressed. And I really appreciate having me on.
Oh, sorry. Say that last part again. I think
I just said I appreciate you having me on, Tom. It was good.
Thank you. No, it was great. I actually really enjoyed the talk. I know my audience expects like price updates and stuff, and those are coming later. But thank you very much, guys, for tuning in for another episode of On the Record, which lately have had a slight focus on lawyers and regulations, but that's the current environment. And it's important, and you need to understand why that is. Once again, I am Tone Vase. Check out all of my content on my YouTube channel, along with the audio podcast on the World Crypto Network. Thank you guys again for watching, and see you all on